order became high profile this legislative session. A new state law focuses on how accused criminals are held or released to wait for trial. Locally, Miami-Dade courts were already reviewing that process and dealing with the politics of crime and punishment. Turns out the new state law and the Miami-Dade project have much in common. Nushin Sayfie is chief judge of Miami-Dade courts, live with us today to take us through those changes. Your Honor, great to see you.
Great to see you too. Thank you for having me.
Again, so we talked all about this a few months ago when you were in the thick of it. So now that the law is signed, sealed, and delivered, what practically has changed?
So, I think we still have a few months. The law doesn't take effect until January of 2024. So we have a few months to sort of figure out the specifics. But we were happy to see that there were definitely some parts of the law that were putting into effect what exactly we were working on with our plan. So that's, good news, and hopefully it's going to help us deliver what we were planning on delivering all along to the people of Miami-Dade County, which was, an increase in public safety and just better processes.
So practically speaking, when we talked a lot about, or the headlines talked a lot about bail reform. And to your point, that was kind of a misnomer because bail reform, frankly, scares a lot of people. People who are concerned with safety don't want accused criminals in their neighborhoods, for better or worse. So what has the political rhetoric done to sort of overshadow the practical nature of what we're seeing now? What will happen in that courtroom?
So I can't speak exactly to what's going to happen. I can tell you that the reason that I was repeatedly telling you when we spoke last, and certainly other news outlets and the various county commissions, the various city and county commissioners that we spoke to about this we were not intending to change bail. Bail was not going to change at all. Bail is an avenue for judges to use when they're going to release someone, and that was never going to change. What we were hoping to improve was just pretrial processes overall. And one of the biggest things we were hoping to improve was that we have many, many offenses in Miami-Dade County, and certainly in the state of Florida right now, that don't require a first appearance hearing. So because they are bondable offenses and they're not non-bondable offenses and they are not otherwise held for first appearance, a person can post a bond and get out without seeing a judge. And that's one of the things that we were hoping to rectify, and it's definitely something that was addressed by the bill. So that's one thing that I expect is going to change.
Is that a financial component? In other words, if someone is able and has the financial resources to post bond and not even show up, that is not equal justice. Is that valid?
So that's the concern for two reasons. One is that it's only focusing on finances, and in fact, you're not even going to see the person to know what their finances are. So the bail, our bond schedule is need blind. It's finance blind. So you've got people who can afford to bond out, and the judge never gets a chance to review the case to see if there's a victim that needs a stay-away order, to see if what the person's prior history is, to see if the person has a prior history of failing to appear. And that is one of the things that we were hoping to rectify. And that's one of the things that the assessment that was going to be done, and I believe Corrections is already using that assessment, was going to give the judge a score that included their history of failing to appear, their prior history, and that would all be included in a recommendation to the judge. So that's been at least partially addressed by the new bill, because there are going to be a vast number of offenses that are going to have to see a first appearance judge before they can be released. And then the judge will be able to review those factors and hopefully make a good decision about whether to give bail or some other form of release or to hold the person.
I think a lot of people don't realize what a complicated equation a bond or a bail decision is vis-a-vis a history of a criminal or an accused criminal and the actual crime. I want to just ask you about one thing that this bill does among so many. It prohibits a person from being released prior to the first appearance if he or she has been arrested for a particularly violent or heinous crime. Wasn't that the case anyway? Why would a person accused of a violent or heinous crime be able to bond out?
So I want to say yes and no. So we have a series of offenses that are either life felonies and that are non-bondable, and they have to see a first appearance judge. We also have a statute in Florida that requires anyone charged with domestic violence, they have to see a first appearance judge. But there are a lot of offenses that I think people would consider violent that don't need to see a first appearance judge. For example, you can commit an aggravated battery with a firearm, and if it's non-domestic, you would be able to bond out today without seeing a first appearance judge. And I think most people would agree that that would be considered, at least if maybe not heinous, but certainly violent. And depending on the circumstances, it could be heinous. So the answer to your question is sort of a yes and no. And that was one of the things that we were trying to address with, really the years long effort that we've been at trying to make sure that we could improve. Miami's certainly done a great job of keeping the crime rate down. And our hope was to do even better and to make sure that people that are charged with, for example, firearm offenses would see a first appearance judge, which right now today they do not, depending on the nature of what they're arrested for. So my hope is it's going to be better.
Is there anything, I remember when we spoke, I feel like our job here in the news is to kind of take politics out of things, because sometimes political messaging really blurs the reality of what's happening. And I feel like some of this occurred as this project in Miami-Dade was going on and the state law was being written. So I'm just going to throw out this question. Is there anything in this state law that makes your job a bit more tougher, politically speaking?
No, I think honestly, the state law in the end actually did a lot of what we were intending to do. I said, I don't want to speak, to the politics. I can just say that clearly there was a pretty big misunderstanding for whatever reason in the community about what the multi-agency effort, and I say multi-agency because it was an ongoing effort with the courts, the state attorney, Catherine Fernandez-Rundle, Carlos Martinez, the Dade chiefs of police, and years back it had started with my predecessor. And it was, county commissioners were involved at that point too. So it's been really a years-long effort, but most recently, we were kicking into high gear. And I think there was just, for whatever reason, a lot of misunderstanding out there, notwithstanding our efforts to try to correct the misunderstanding about what we were trying to do.
Or ours.
Yeah, and this new law, I think, does do a lot of what we were intending to do. And we're going to continue to do what we always do, which is work within the parameters of the law to do our best to deliver safety and also a fair system to the people of this county.
Your Honor, Nushin Sayfie, Chief Judge of Miami-Dade Courts. Great to have you on the program. Great to see you.
Thank you so much, Glenna. Great to see you too.